Hello.
We are honored to welcome you all today on behalf of Bharat International Business School. Today, we gather here to engage in a thoughtful conversation on the challenges, opportunity, and the potential need for a new outlook of India, that is, does India really need a new constitution after 76 years of independence? The Constitution of India is not just a legal document, it is the very soul of our democracy. It lays down the foundation of our government, defines the rights and duties of citizens, and sets the framework for our collective journey towards justice, equality, and liberty. Every year, on November 26, we celebrate the adoption of the Constitution of India. It was on this very day that the framers of our Constitution pinned their signatures, giving shape to the guiding principles that will govern our great nation. It's a reminder of our shared commitment to the ideas enshrined in the remarkable document. It is a day to reflect on the values that bind us together as a diverse and vibrant nation. In the spirit of intellectual exchange and democratic dialogue, we have brought together a distinguished panel of experts, each with such a new perspective on today's question, that is, does India need a new constitution after 76 years of independence? The panel consists of Retired Honorable Justice R.T. Gauba Sir at Delhi High Court, Retired Honorable Justice P.K. Saxena, Additional and Sessions Judge in Delhi, Mr. P.A. Badrinath, Director and Chief Executive, CHS and Principal Advisor at Ministry of Information and Broadcasting, Professor Dr. Nishtha Jaswal, Vice-Chancellor at HPNLU, Himachal Pradesh, and last but not the least, Advocate Bharat, Sir, founder of Bharat and Associates. May I please request our Vice-Chancellor, Director Sir, and all our esteemed panelists to come forward for the lamp lighting. Established in the year 2004, gives its affiliated to Guru Gobind Singh International University, Delhi, and is approved by All India Council for Technical Education, Ministry of Education, Government of India for its management courses, and Bar Council of India for its law courses. The Institute conducts program of MBA in International Business, BBA, Integrated BBA LLB Honours, and Integrated BA LLB Honours. The Institute is accredited as A grade by NAC and assessed as category A++ by Joint Assessment Committee of Government of Delhi and Guru Gobind Singh International University. The Institute has been rated grade A by Prime Audit Academic Cell of GGS University consecutively for the past 12 years. This has also been rated number 2 by Times B School Survey in 2018, 19 and 2021. Established in 2017, the Legal Aid Clinic at Center for Legal Studies, Bharat International Business School, aims at empowering the oppressed and providing solutions to their problems by using law as a tool of social engineering. We strive to support people who cannot afford legal assistance. In India, the journey to legal aid is not a low-priced road to walk on, and not everyone can pay such a huge monetary amount at every trial. This is where we come in. The people at legal aid clinics of CLS gives acts as a bridge between legal aid. poor, oppressed and illiterate people, and we make every possible effort to ensure that there is an easy access to the justice delivery system for the marginalized group. Well, coming back to today's agenda, this panel discussion promises to be both enlightening and thought-provoking. As we explore into a pertinent question, does India need a new constitution after 76 years of independence? We have a distinguished panel of experts over here, and now I would request our Honorable Director, sir, to take the mic and introduce our audience to the esteemed panelists. Thank you so much.
Respected Honorable Vice-Chancellor, Honorable Retired Justice R.K. Gauba, Retired Honorable Justice P.K. Saxena, Mr. K.A. Badrinath, Professor Dr. Nishtha, Jaswal, and Advocate Bharat Bhushan. A very good morning to all of you and welcome for this panel discussion on whether India needs a new constitution after 76 years. Before we start this panel discussion, I would like to set the tone of this panel discussion with a few words of mine, and later on we would like to listen to the words of wisdom from your side. Constitution Day, also known as Samvidhan Divas, is celebrated in India on November 26th each year to honor the adoption of Constitution of India. This day holds significant importance for several reasons. First, the Constitution Day commemorates the day when the Constituent Assembly of India adopted the Constitution in 1949. It signifies the culmination of years of deliberation and efforts to draw a comprehensive and inclusive Constitution. So that's the first point. We started with comprehensive and inclusive Constitution at that point of time. The day is an occasion to remember and pay tribute to leaders and visionaries who played a pivotal role in shaping the Constitution, with Dr. B.R. Ambedkar being the chief architect. It acknowledges their commitment to building a democratic and an egalitarian nation. Constitution Day is a reminder of India's commitment to democratic principles, social justice, and fundamental rights. It underscores the importance of upholding the values enshrined in the Constitution. It provides an opportunity to educate citizens, especially the students, about the Constitution, its key features, and the rights and duties it guarantees. Various educational institutions organize events and discussions to promote constitutional awareness, and we are also one of them. The day serves as a moment for citizens to reaffirm their commitment to the constitutional ideal of justice, liberty, equality, and fraternity. It encourages people to reflect on the significance of these principles in their daily lives. Constitution Day emphasizes the importance of constitutional governance and the rule of law. It reinforces the idea that all individuals, including those in the position of powers, are subject to the principles outlined in the Constitution. India's Constitution celebrates its diversity by providing for the protection of the rights of all citizens, regardless of caste, creed, religion, or gender. Constitution Day serves as a reminder of India's commitment to unity in diversity. Let's come to the topic. Does India need a new constitution? It's a complex and a burning question which we would like to answer today with the help of panelists. But there are a few points on which we would like to deliberate upon. The question of whether India needs a new constitution is a complex and often subject to diverse opinion. And the diversity of the opinion will be seen here with people coming from different walks of life. As of my knowledge, cut off in January 2022, the Indian Constitution has undergone several amendments to address changing needs and challenges. Here are some perspectives on whether India needs a new constitution. Let's discuss whether we go in for amendment or rewriting. Some argue that existing constitution is flexible enough to accommodate changes to amendments. They believe that a complete rewrite might not be necessary and amendments can address the emerging issues. Our constitution is evolutionary in nature. The Indian constitution is often considered a living document that can evolve over time, and it has been doing so. Its adaptability has been demonstrated through amendments and judicial interpretations, allowing it to remain relevant. It addresses to contemporary challenges. Supporters of the new constitution argue that contemporary challenges such as technological advancements, environmental concerns, and involving social dynamics may require a fresh and comprehensive perspective that a new constitution could provide. That's a point in favor of new constitution. Inclusivity and representation. Some suggest that the new constitution can further enhance inclusivity and representation, ensuring that diverse voices and perspectives are adequately reflected in the governance structure. We also need to keep in mind federalism and center-state relations, and discussions about redefining the balance between the central government and states, especially in the context of federalism, have fueled debates on the need for constitutional reforms. This leads to amendments. Socio-economic rights. Advocates for a new constitution may emphasize the inclusion of additional socio-economic rights and measures to address issues like poverty, healthcare, and education more explicitly. It also requires public consultation. The process of drafting a new constitution would likely involve extensive public consultation to ensure that aspirations and concerns of the diverse population is taken care of. Not the last and not the least, constitutional values. Regardless of the position on the need for a new constitution, there is a consensus on the importance of upholding constitutional values and ensuring that existing constitution is a robust and effective instrument. In conclusion, the question of whether India needs a new constitution is a complex and multifaceted one. It involves weighing the strength and adaptability of the current constitution against the challenges and aspirations of a rapidly changing society. Any decision in this regard would require careful consideration and adherence to democratic principles. With this background, we have eminent personalities from legal and media profession to deliberate further on this event. I now take the opportunity of introducing the list of panelists and the eminent personalities who are with us. Retired Justice R.K. Gauba, sir was selected to and joined Delhi Judicial Services on 19th, presided over the courts of Civil Judge, Metropolitan Magistrate, and Rent Controller. He was promoted to the Delhi Higher Education Service on 20th November 1997 and served in many jurisdictions, including a special judge for NDPS and anti-corruption cases, as also the municipal election disputes. He also exercised appellate jurisdiction under Rent Control Law, Public Premises Act, and against orders of MCD and DDA Appellate Tribunal. He was Chief Metropolitan Magistrate for Delhi during 1998-2000. He also presided over MACT Act, Sessions Court, matrimonial cases. He was the Registrar of Vigilance at Delhi High Court and Supreme Court during 2005 to 2010. He also served on deputation as Officer on Special Duty, Judicial, with the first Central Review Committee under Kota. He was elevated to High Court as an additional judge with effect from 15th December 2014 and was appointed as permanent judge of the Delhi High Court with effect from 2/6/2016. He retired ultimately on 3/12/2019. We welcome you, sir, and may I now request Honorable Saxena ji. Sir has completed his LLB from Delhi University in First Division. He is also an awardee of Sukhdev Girdhari Lal Grover Prize. He cleared Delhi Judicial Service in 1986 and held several positions including Metropolitan Magistrate, Civil Judge, Additional Rent Controller, Presiding Officer Labour Court, Additional District and Session Judge, Special Judge CBI, Joint Registrar, High Court of Delhi. He is also a distinguished mediator. Sir retired in 2013 and resumed practice as an advocate, specializing in civil and criminal matters, arbitration, writs, and petitions. He is also an esteemed member of Delhi International Arbitration Center. I request our Honorable Vice Chairman, sir, to do the floral welcome. We have the next panelist, Mr. K. A. Badrinath. Mr. Badrinath is a senior journalist and policy editor of Financial Chronicle. He visited many universities to deliver a lecture on making of the union budget for students of the faculties of different disciplines, including management, law, and mass communication. He has over 27 years of experience as a financial journalist. May I request Honorable Vice Chairman, sir, to do the necessary welcome. I now take the opportunity. She has teaching experience of more than 33 years and she is a specialist in constitutional, administrative, human rights and environmental law. She has authored a number of books, of which prominent are Role of Supreme Court with regard to the right of life and personal liberty. May I request Honorable Vice Chairman, sir, to do the research in the field of commercial disputes, company law, matrimonial matters and criminal civil litigation. They also offer expertise in legal drafting.
Quickly grab a moment and bring on the stage the moderator of this event and also the President Legal Aid Clinic, Mr. Raj Singh, to take over the panel discussion.
Well, thank you, Navya, for such a sweet and short introduction. I loved it. With such an eminent panel over here, I also have to be on my toes all the time to try to match that level of expertise. So we all know that the panel we have over here, we are here to discuss, does India need a new constitution? First of all, I'd like to thank all the panelists that we have over here. Starting by Retired Justice R.K. Gauba, sir, former judge at Honorable High Court of Delhi. Retired Justice P.K. Saxena, sir, former Additional District and Sessions Judge, Delhi. Professor Dr. Nishtha Jaswal, ViceChancellor, HPNLU, Himachal Pradesh. Mr. K. A. Badrinath, Director and Chief Executive CHS, and finally Advocate Bhushan, sir, Founder Bhushan and Associates. Welcome you all. As we know that we have the topic in front of us, does India need a new constitution after 76 years of independence? Before starting with the panel discussion, let me give you a brief about what we are actually discussing today. We need a new constitution, but exactly what are the sowing seeds of the constitution? With India's independence, it was clear that the freedom from British rule was meaningless without a constitutional order that governs democracy, equality and unity and diversity, because these were the promises that gained the intellectual ballast and the support of the people to overcome British rule. India's progress in the 21st century is dependent upon the re-ignition of these basic values only. Our constitution may be young, but it has gone through some tremendous changes over the last several decades. What is even more awe-inspiring is that it has demonstrated remarkable resilience, surviving all such assaults on it. Obviously, with the Supreme Court being as the guardian angel. The National Constitution Day, which we are here today to celebrate, also known as the Samvidhan Divas, is celebrated to commemorate the adoption of India's constitution and promote constitutional values among the citizens. I quote Dr. B.R. Ambedkar, "The constitution is not mere a lawyer's document, it is a vehicle of life, and its spirit is always the spirit of age." If that is the case, and the constitution is indeed the vehicle of life, then the question is, are we on the brink of needing a heart transplant? This is what we are here to discuss today. And as much as we would love to have this discussion go on and on, we have a limited period of time only, so we're going to break this discussion into 4 distinct chunks. Firstly, we'll ask our panelists about their overall opinion on the topic that whether they do support or oppose the idea of India needing a new constitution. Following that, a few questions from my side for our panelists, and the rest will come from you, the audience, in an open mic question and answer session. And finally, let's try to derive a conclusion with the arguments that our honored panelists have given. So starting, let's hear our panelists whether they support or oppose the idea for the need of a new constitution after more than 76 years. Please, sir. Because as we see that the Department of Law, Chicago University clearly says that constitution in general do not last very long. The mean lifespan is roughly around 17 years.
Our constitution had a life of 73 years so far, but last amendment was in January. So that means it's still alive. We can continue to work with the same constitution or we can change and in fact non-committal about it. Because it's the persons who handle working of the constitution. It's the persons who are working on the constitution, using the constitution to do something in the society, they actually matter. Bad constitutions can work in a very good manner, a good constitution can work in a very bad manner. This is the reality. So therefore, I am in fact quite neutral about it, whether we continue to work with the same constitution and we have another constitution. More or less, this constitution has served the purposes as has been noticed by Bharat sir and you also. This constitution has lived up to our expectations so far. And it's very dynamic instrument which has been given by our Constitutional Assembly to us. 105 amendments so far have taken place. The constitution remains deep. Yes, very good. What is matter of concern for me is, in fact, this constitution at that time it envisaged to bring about certain changes in society very fast. Certain reservations were provided for initially for 10 years. It was thought that by giving reservations to a certain class of persons, perhaps the equations in the society will get changed very fast. But we have to extend it every 10 years. Equations in this society have remained static. Not exactly static, I should say. These are changing very slowly. So if at all we want to bring some changes, we have to stir up those things so that the society changes. What are the changes which were envisaged in our constitution? Were very simple things. Our society was considered as a feudal society, constituted society. And a feudal society should become a modern society, more liberal, that type of society. Or these constituted things get done away with so that everybody in the terms used as equality is really achieved at a right time. We are still far away from those kind of things. So from that perspective, our constitution has really failed us. So something needs to be done about this constitution, either by changing bringing some amendments to the constitution or bringing a new constitution, that these kind of things become faster. In that direction. I will make my suggestions on this also, and from that, as I said, that I am basically neutral about it. So whether the executive is doing something properly or not, there are two things which matter. One is the executive has to face elections. If people become cautious, the election matters. If people are not cautious, election will not matter. We have equations based upon caste, people vote on the basis of caste, or certain other things which are not really concerned about at that time, about the issues which affect them. And those of us who have to make them understand about the issues, they also fail in their duties. So elections have not really served the purpose of ensuring that the executive is able to work, deliver the things to them on this aspect. So another thing is judiciary. Institution of judiciary is an institution which has to, I am for activism of judiciary. And judiciary could be active. There were certain, sometimes it is considered as a negative thing. Activism of the judiciary is considered as a negative thing, that they try to do things which legislature are doing. So activism is supposed from that perspective. But activism has helped us and will help us further. Because we have seen, just as I explained that the constitution, our electorate people, they vote on the basis of their feudal affiliations. Or some other considerations which are not concerned about the result that will affect our society. So from that perspective, where we are in a situation where judicial activism will help us. Of course, one allegation which goes against judicial activism is that they try to impose their personal things. then that will be that we have to have judiciary properly selected. So that the persons not only knowledgeable but value-oriented persons also come with the judiciary. So that also becomes important. And if we have judiciary which is activist and is protected there, what happens by the judiciary trust tends to be weaker because there are certain things like certain persons are rewarded after their retirement, certain people are not rewarded after their retirement if they take some step, which apparently is maybe according to their concept of law, but the government perceives that against them. So they may not be rewarded. So from that perspective, they try to make judiciary affected by these kind of things. So we should have a judicial system with the retirement age from 65 to is raised to 70 years. This is what I would think is the proposal that I gave on this text. And there should be no further incentives after that. Because those kind of incentives given by the government try to make this judiciary late. So therefore, these kind of the changes which are very necessary, and if these changes come first, because this is going to be harming all of the things. If these changes are brought first, then subsequent changes will automatically start coming. Even the bad constitution would work properly. Our constitution, as has been pointed out by the learned chairperson, that this is the best possible thing. It has evolved itself and is a living institution. It has been and it will continue to be living institution. And if it is changed, a new constitution is brought in, the value system has to remain the same. This is also the precept that we are working on. Will not matter. With this, I will just end my submission.
I'll just start with a Samatan Suktam from Retd, because that is very important. Whatever we say, whatever we think, there must be uniformity. Samani va akuti samana hridyani va samana mastu ho mano yatha vaisu sahasati. Which means collected be our purpose, united be our mind, harmonious be our feelings. The same way in which this nature exists in togetherness or wholesomeness. Because Constitution of India, which is a sanctorum, and I can admit before the panelists and the audience that perhaps this is the only temple where I bow before. And I can share with all of you that I am a poet by heart. So just 2 lines in the beginning. संविधान नहीं है केवल कुछ पन्नों की कहानी, संविधान नहीं है केवल कुछ पन्नों की कहानी, यह तो है मेरी आत्मा, निष्ठा, धर्म, ईमान, मेरी जान. This is the we find in the writings that Constitution is a living document. Before we talk about changing it, we must just have introspection of under what circumstances we had this Constitution. Those were the days when we got independence, partition was there, riots were there, killings were there, and even if we had the independence, still the economy was totally impoverished and we were at the edge of balkanization. So very important question. In fact, if you read Rajiv Thawan's book, The Constitution of India, very important question he raised at that time, whether Constitution has a soul. Now here, he gives the general opinion, because we are just traveling, just taking this journey with that general opinion only, that there are only arrangement of certain situations like use of political power or judicial power or legislative power, or in simplest possible ways we can say separation of powers and allocation of powers. These 2 things which are very, very important there. Keeping this in mind, and then I would just make a statement again. If we talk about Grenville Austin, he refers to the making of the constitution, cornerstone of a nation. He refers to the values of the constitution, and we know all these values which are enshrined in the preamble of the constitution. It has become a fashion. Today we are also part of that fashion scheme only, that we disparage the founding fathers, we disparage the constitution and think of changing the constitution. What was given to us by founding fathers and mothers? Now, Director Sahab said, Shri Bharat Bhushan ji also said, we don't have to change the constitutional values. I'll simply say, we cannot change our soul. Our soul is the constitution. So if we look at any religion, religion always talks about purity of our soul. Soul is always pure. When we wrap it with a body which is mortal, then issues arise. Changing the soul is not required. When we bring purity in the working of the body, that matters. And what it means, what we have been doing. Even I can quote Dr. B.R. Ambedkar when he said, no constitution is bad. It is made bad by those who work on the constitution. Few instances I can give. What we have achieved, where we lack. If you open the preamble, see, I hope nobody else of us has forgotten Resourceperson case where Supreme Court very rightly said, preamble is the key to open the minds of the framers of the Constitution. So look at the preamble. All the values underlying the Constitution we find in the preamble. Whether we talk about sovereign, socialist, secular, democratic republic, or we say justice, equality, liberty, all these issues, all these values. Most important, fraternity assuring the dignity of the individual. Article 21 of the Constitution, its scope was widened by the Supreme Court of India merely by interpreting that right to life means right to live with human dignity. And just because right to life includes right to live with human dignity, you name any fundamental right and that is part and parcel of our fundamental rights. And we cannot enjoy this dignity, even though we say fraternity will assure the dignity, but we cannot enjoy this dignity unless and until there is a fraternity. Now, what is a fraternity? Fraternity, brotherhood. And we cannot have unity and when we talk about balancing power with liberty, so many amendments wherever required, working after three organs of the state. Now we in fact innovated and further elaborated the concept of separation of powers to checks and balances, and now we have the spirit of rule of law flowing throughout the Constitution. If I just refer to Article 14. Initially, we were only confined to the principle of no discrimination. After E.P. Royappa's decision in 1974, we talked about no arbitrary exercise of power. As a consequence, we talked of and we adopted Wednesbury principle from the English decision of Associated Provincial Picture House Limited versus Wednesbury Corporation in 1947. In Delhi Science Forum versus Union of India in 1996, we just adopted. But here I would like to talk about the soul once again. Soul lies in our religious scriptures, maybe any religion. If I just refer to Hindu religion, we talk about dharma. Dharma is the righteousness. We find a place, then we find one very important concept in our Shastric advice, that is this Purusharth. Purusharth, which means Purush plus Arth. What is the objective of human life? There are 4 pillars of Purushartha. This Dharma, Artha, Kama, Moksha. Now values. We think of changing our constitution. Where we find this Dharma, righteousness? Everywhere. Starting from preamble, part 3rd of the constitution. I'll just say Article 13. No law to be passed which violates the fundamental rights of the constitution, power of judicial review. If I talk about directive principles of state policy which imposes kind of duty or guidelines for the state, if I just refer to the fundamental duties, even though specifically, expressly it was added by 42nd Amendment Act, but can we say that rights can exist without any performance of duty? And the first duty is to abide by the Constitution. And gradually, because we talk about making a new Constitution, I am not satisfied. I am not ready for that. Why? As per need, we have been amending the Constitution. As per need, the Supreme Court of India is interpreting the Constitution in such a way that we have a good pace with the changing needs. I can just refer to the concept of a constitutional morality. Distinction between right and wrong. So constitutional morality or inner morality of the Constitution. Now what is right under the Constitution, what is wrong under the Constitution? In fact, the restraint on, when we talk about even exercise of judicial review, restraint on the power of all the 3 organs of the state is that it has to be in consonance with the Constitution. That means we find the limits even for the working of the Constitution. And if we just talk about the issue of change in the federal structure, of course, as per needs, initially we had mainly talked about unitary power, asymmetrical federalism. Of course, then we need to talk about cooperative federalism as well as competitive federalism. Is it necessary to figure out each and every word in the Constitution? Already the Constitution of India is the lengthiest constitution in the world. Still, can we have every detail? Even if today we think of reframing or remaking of the Constitution, I think again after a few years, we will again think, because we can't just lay down all the details. And then my fear, maybe my fear, it may not be fear of the whole population of India, that don't allow Constitution to be a toy in the hands of different governments who rule the country. There must be something, some supreme power, because we say supreme power is we the people of India. Shri Bharat Bhushan ji very rightly said, how? Through elections. What happens during elections? Experience speaks more than what is written on the paper. So it is better if we save this Constitution, we make changes wherever required without changing the spirit of the Constitution. And I am a great fan of Supreme Court, and most of the times I say perhaps the only panacea lies in the hands of Supreme Court, as the experience shows. So let us wait and watch that without any conflict between different pillars of the state, because during chaos no system can function, and ultimately the suffering will be of teeming millions of India. And that then such a constitution or such a working will not be the dream of Mahatma Gandhi, because he always wanted to strive towards having the constitution where there is no patronage, where every person of India should have a feeling that this country belongs to it. And finally, I'll just conclude. As I said, I'm a poet. I'll just recite my poem on this constitution. संविधान कुछ पन्नों की कहानी है, जानती नहीं। संविधान की आत्मा ठिठक सी गई है, मानती नहीं। This is the answer. संविधान की आत्मा ठिठक सी गई है, मानती नहीं। बहुत ऊंची है सुबह संविधान की, हिमालय से भी ऊपर गूंजती है। गंगा की धारा, परिंदों की उड़ान, फूलों की खुशबू हर दिल में ऊपरी है। इसकी सतह पर न जाने कितनी सरकारें गिरी और बनी। इसकी सतह पर न जाने कितनी सरकारें गिरी और बनी। न्यायालय के कक्षों में कितनी धाराओं पर खूब उठनी। संविधान नहीं रहा स्थिर, ढलता बलता पनपता गया। हम सब जन, हम सब जन से शब्दों का दायरा उधेड़ता और बुनता गया। तकनीकियों ने विकास के नाम पर जीवन बदला। See, we have changed ourselves from Gurukuls sitting under the shade of the tree, coming to the AC halls and now using AI. तकनीकियों के विकास के नाम पर जीवन बदला। संविधान ने शासन और शक्ति को तर्क पर डटोला। मर्जी न तेरी न मेरी, this is very important, we have to think of commoners. मर्जी न तेरी न मेरी, तराजू है सही जजमेंट का। राष्ट्रीय सुरक्षा या जनहित में भी पारदर्शिता संचित है। Transparency, and then we talk about accountability. मैं नैसर्गिक अधिकारों के लिए लड़ता रहा। मैं नैसर्गिक अधिकारों के लिए लड़ता रहा। मेरे ऊपर मुझे बनाने वाला हंसता रहा। कुछ देवदूतों ने मेरा दर्द दिलो दिमाग से निहारा। कुछ देवदूतों ने मेरा दर्द दिलो दिमाग से निहारा और उच्चतम न्यायालय ने मेरे अस्तित्व के सम्मान को सहारा। पारदर्शिता के नाम पर सूर्य की किरणें मुझे टटोल गई। मैं सोशल मीडिया पर प्रकट बेमोल हुई। हाउ वी हैव चेंज्ड। संस्कृति और संस्कारों की कसौटी बिखर गई। संस्कृति और संस्कारों की कसौटी बिखर गई। संविधान और सामाजिक नियमों की लड़ाई और बिखर गई। This is what we are talking. And मैं जानना what is my desire and I pray to God, रब सुबुद्धि दे मुझे, रब सुबुद्धि दे मुझे, संविधान का दिया जलाती रहूं। रब सुबुद्धि दे मुझे, संविधान का दिया जलाती रहूं, मगर भारतीयता की मशाल बुझने से बचाती रहूं। मगर भारतीयता की मशाल बुझने से बचाती रहूं। न जाति के कांटे चुभे, न धर्म की तलवार काटे। न जाति के कांटे चुभे, न धर्म की तलवार काटे। हम सब मिल राष्ट्र प्रेम के फूल ही बांटे। हम सब मिल राष्ट्र प्रेम के फूल बांटे।
That we did in the next constitution class is over. Over to you, sir. This one is on.
Stiff-necked, heartless, money-making machines are the most, what we call, vulturous variety. This is the variety that goes with the legal profession perhaps. And खूब चूसने वाले लोग हैं, जो बच्चे ऐसे हमारा उदाहरण ये है। This is what many people like to feel. To see a lady speaking so well and so passionately about the Constitution, maybe I have to change my views on how I view the legal profession, or how I view the so-called upholders of the Constitution and the constitutional morality on which the Chief Justice of India speaks. I don't know if all of you have gone through the Indian Express interview of Justice Chandra. So he talks about constitutional morality and things like that. So the two speakers have said the tone already, and nice background by the honorable professor. So it makes our actually our life much easier in the discussion, I guess. So maybe we should make it more conversational in terms of and participate there, so that we don't just blurt out what we have prepared, and then after that the horn goes silent without any how do we respond, what are that kind of stuff. As a journalist, I've run into law enforcing agencies, have appeared before the judges because they say that, okay, I don't think one incident, sir. So, I was investigating a scam on the Sukhoi deal. As an investigative reporter in the Hindustan, we broke the story on that Sukhoi aircraft, fighter aircraft about to be acquired by Bharat from Russia. And the amount of money that they are going to be there, and the irregularities in this. I'm not against acquisition from Russia, US or Europe, but the irregularities going into it, and the pricing issues and all that. So the government took me to the court. Right now I'm in the government. God forbid. I'm taking someone else to the court. Sorry. So then I went before and the Lordship said, Mr. Badrinath, have you committed a crime by leaking the most secretive cabinet document and quoting it verbatim in the news copy? Sir, if it is a crime, I concede that I committed a crime. But if you still say that I should be punished, I should be allowed to say what happens. Very benevolent judge, I don't remember the judge's name, but he said, just go ahead. I had to say that, look, so whatever I've done is part of my profession, to bring out good stories to my readers in the best of it. Like the judiciary puts a lot of people under scrutiny, the press also has a role to do that. So we try to do it, sir. But still, the official secrecy and all that is being violated. How can you justify this and all that? I have no clue of the provisions and the laws and everything. But only one thing I remember from my journalism days is that I have some amount of immunity, press immunity. And I said, sir, can I take shelter under the press immunity or something like that? Some provisions are there. My office will appoint a lawyer if you think that it's a big crime I committed. By investigating an irregularity, it is expected to be committed any time now. Hard joke है So normally the press person कभी किसी के सामने हाथ नहीं जोड़ता. तो जज के सामने जब जाते हो कान पकड़ के हाथ जोड़ के खड़े हो जाओ. बस बंदा फ्लैट हो गए. This fellow's name I read every day at the front page of Hindustan Times और ये बंदा आके मेरे सामने खड़े होके बहुत शरीफ लड़का, hardly is 28. How did this happen? He was in a little fix. How do I deal with this fellow? So, by the time, of course, my lawyer came to my aid because Hindustan Times had appointed someone to defend me. The case went on and okay, I was by Kiya, what do you call it in legalized terms? You just said you are done. So, it was only one or two incidents where I had pushed it to that. But my impression about the big topic that you have set for today is that I was just reading through one news report this morning. It said that France has rewritten its constitution about more than 20 times. 1791 to 1958. They have rewritten their constitution 12 times before it is today called as the Fifth Republic. Should we take a cue from that? One question for the audience. In fact, I want to give a counter poser. All of you, posers to all of you, youngsters, you should come with ideas. Nepal, just our neighbor, next door neighbor, it says that okay, 6 times constitution has been rewritten from 1948 to 2007. How do you compare ourselves with Nepal? Chota sa Himalayan kingdom, I sir. It's our backyard. So do we have to go by what they have done? Or is it indicated that we need to be flexible? Just a thought that's it. Third, in South America, we have a small country called China. 2020, they decided to rewrite their constitution. And only the decision to rewrite the constitution, sir, led to the change of the government back. So, whether you rewrite or reframe your constitution, there are a lot of factors that need to be taken into consideration. One, is it politically expedient to rewrite a constitution is a question that many of us will have to ask ourselves. Because politicians will not do anything unless it is comfortable for them. These days, maybe even, sorry madam, I will be overstepping myself, because these days the highest echelons of the Supreme Court only want to hog the headlines. Every day, page one cover kaise ban sakta hai. Because every day, now, because I tell you why sir, because earlier we used to have one legal reporter in Hindustan. Now I have 7. 7, only in Delhi. Yo. Then, Times of India, we have a all India network of legal reporters because from, we don't know from where some judge will say something and I am missing the report and I lose my job. So what happens is, courts have become a big issue for nice catchy headlines. Beautiful headlines. Every day after day. अब सड़क पे जो आदमी को क्या लगता है कि कोर्ट कचहरी जाने से ये था, he will virtually shake himself. अब कॉन्स्टिट्यूशन की बात तो बहुत बड़ी बात है. So what I am trying to say, one political experience, what the judicial system wants is another issue. Third part I would like to bring in is there a lack of consensus on the present constitution? If there is lack of consensus on the present constitution, do we have to change it completely, rewrap it, preserving its soul, like Professor Nishtha has at least थोड़ा सा सुझाव के रूप में अपना कविता में बहुत प्यार से समझाया, so that she would not hurt anyone, isn't it? So this is something we need to consider. Is there a lack of consensus? Of course, a learned professor, I'm not learned. So learned professor said there is a vertical divide. कुछ लोग बोले कि भाई आगे बढ़ो, नया कॉन्स्टिट्यूशन ले आओ, नया भारत के लिए नया कॉन्स्टिट्यूशन, अच्छा स्लोगन भी बन जाएगा. मोदी साहब को मत बोलो, then he will do that as a tomorrow's slogan. वो भी एडवर्टाइजमेंट में आ जाएगा वैसा. अमृत काल से और काले ना I wrote that. सही बात है. So इस अमृत काल में नया संविधान, नया भारत के लिए नया संविधान, इतना कैची रहेगा भाई, क्या बात है. इतना मिर्च मसाला 24 घंटे में मेरा चैनल चला सकता. So point I'm trying to make is from the laughter aside, so why do we need a new constitution is a question that we address, at least. If at all we want to change the constitution, and choti moti kya amendments le aa rahe ho? What is this? Every time there is an issue. Hey, amendment le ke aa rahe हैं. पूरा गड़बड़ है. भारत में जो गड़बड़ होता है ना, सब कुछ कॉन्स्टिट्यूशन के द्वारा ही होता है. एवरीथिंग इज गड़बड़. अब कुछ तो जुगाड़ करो. तो जुगाड़ क्या है? अमेंडमेंट. कुछ ना कुछ कर रहे हैं हम लोग. Point I'm trying to say is that do we go for this or do we go for a complete rewrite? Is a question that has been posed by the learned professor. My guess is at least you lay pathway towards a fresh look towards the constitution. But there can be some few riders saying, A, उनका आत्मा को प्रोटेक्ट करो, जैसे मैडम has suggested. B, all workable things can be retained. C, all new things we welcome. Anything new, और जो सरकारी बोलेंगे कि नहीं जी ऐसी ठीक रहेगी, खालिस्तानी बननी है, तो please take it in. Nice try. Let's see, let's consider it. Let's consider. Let's be open to discussion at least. ऐसा नहीं होना चाहिए हमने जो किया कर दिया, आगे कुछ नहीं करना. There may be a consensus as he had suggested, but someone suggested there should be a national consensus. So consensus की तरफ चलना है क्या? ये आप लोग भी बताएं, because we are all grey haired and person can grata after a year or two. So you have to run the country, So do we need a new constitution? If we need a new constitution, what should be the basis? What is the logic behind it? Can we build a case for it? A watertight case बना सकते हैं क्या हम लोग? Can Gita Institute take this initiative to build a national consensus? Let's begin all the global law professionals to do this. नया भारत, नया सोच, नया constitution. Possibly it will end up as a new wrapping of the Atma, as Professor Madam said. But point is that बदलने से डरना नहीं है. Let's be open and flexible at least in our thinking, in our attitude towards going in for the constitution. I have a few points to make, and I will have only two, 3 minutes. When the Constituent Assembly, most of you must have read, only is like, it's for recall value. Recall value होता है. So 7,635 amendments were considered in the Constituent Assembly when Baba Saheb's committee had proposed it. Then the Constituent Assembly considered 2,473 amendments for discussion. And 114 days it took to over 3 years to adopt the Constitution. Things are like some the Constitution are not coming. And so, if that is the case, with 395 schedules, articles, 8 schedules, and 320 million people those days seeking aspiration. If that is the case, how well are we equipped to change it, and change for what? Change for what? Change to where? In journalism, we are taught 5-6 basic questions, lordships, that why, what, when, where, how, who, which. जब तक ये प्रश्न, ये सवाल आंसर नहीं होता है, so खबर ठप है. That's how we are taught. खबर नहीं लग सकता है जब तक these 6 questions are answered. So the same way, the Constitution has to be rewritten. These 6-7 questions have to be addressed before we make an attempt. This is my considered opinion. And normally people say, sir, British India में कोई बनाया है, अब क्या बनाया सर? थोड़ा change तो करो सर. हम लोग ने काला वाला कोड बना दिया, फिर उसके बाद आप भी कुछ करो ना सर. So, it's not that because many of us law students who know that this 1935 Government of India Act का कट्टन कॉपी पेस्ट नहीं है. नेहरू रिपोर्ट का आधारित है. It's based on Nehru report, which may be very inadequate. Later it was embellished, it was expanded. इसका डेरा बहुत, mission and its influence, its applicability is so huge. I would agree with her. Say we have perhaps the biggest and the largest constitution. Huge book. I used to cover Parliament. Central Hall में जाएंगे, Central Hall Library में, there's a big, big constitution का पूरा book, इतना बड़ा. मैं देखते ही डर के बाहर पीछे हट जाता हूँ. फिर हमको लगता है भाई हमारा इतना लिखी नहीं है. So, but I would like to recall one thing. Let's get rid of this notion that it's a colonial, document that's completely that was consigned to the dustbin. I say, it should be constitution. So, maybe there's some gaps are there which may still want to do something on it. Again here, do you want to rewrite it or amend it further? 100 बारी हो गया amendments, और 100 बारी हो जाएंगे by the time we touch 100 years, 2047 में. तब तक एक नया कॉन्स्टिट्यूशन भी बनाने का अभी से शुरू करो. आत्मा को रिटाइम करो. Let the old school of thought prevail also. Come with new ideas, add into them. freshen it up, give it a new branding, new face. So this is one thing which I thought you must think about. But Baki, well, you people decide and I'm with you. Thank you.
We can confidently say that not only that Honorable Justice in court was flat, we all are flat by our opinion. Over to you, sir.
Please, sir. Yeah, I can give you this. Take it. You can have it out. No problem.
Okay. Good morning. We have already heard 3 speakers. Before I begin, थोड़ा सा इसमें I wanted to say जो prefix justice है वो सिर्फ Supreme Court judges और High Court judges के साथ लगा and other district judiciary officers by designation they may be referred but not by prefix justice. As a student of law, this is what we have heard, we have learned, and it has to be followed. See, topic of discussion is actually very serious and its ramifications, dimensions are very wide. Need for change, in my view, would arise on the basis of certain facts. Our knowledge plus experience, knowledge plus application thereof. Application thereof leads to experience. What does the experience teach us? It is not just an exercise saying that because 76 years have gone by, it will be changing. It does not have a shelf life. We have heard, we have learned, the law professors teaching us, honorable judges telling us that it's a living document, it's not static. So, and saying that if you need a heart transplantation, please get it done. Sounds very simple. But please, when one reaches that stage, only then you start realizing what it means. Sir said, we have grey hair, some are lefts, others may not have even grey hair. See, the point is, we have to realize the importance what we have at hand. It is very easy to underestimate, undermine whatever we have. This is the human temperament. As a childhood think going to school is the worst part. Doing of homework is the worst thing. One would want to play. We as seniors would tell the child, no, you have to study because playing all the time will make you good for nothing. But as adults, we realize that playing is also very important. Maybe equally, maybe less, or maybe more as the study. So therefore, in my humble view, coming from district judiciary, see, ideals may be very lofty. It may sound very good. Let's do this exercise of changing the constitution. But in my humble opinion, change should be thought of once it is necessary. Short of that, provision for amendments are there. The framers anticipated all this. Time would never be static, it will keep changing. Situations will change. Chicago or France or, see, we have been seeing all over. Their considerations are different. As human beings, we have to say what are the ground realities. You see, now I would like to just share, because topic is very comprehensive And we have to see whether the existing constitution is inclusive also. As district court judicial officer, my effort, not conscious, but since the time of joining the service, was that whatever you do, even as a magistrate, initially we thought probably constitution is not to be applied here. That was the perception. But gradually experience showed no. The poorest of people who did not have even access to justice, when one appears before the court, is brought by the police, then what are his rights? As students of law, we would know, suppose if a person is arrested in the case of a bailable offense by the police, what does one do? As students of law, you must have learned by now, offense is bailable. Police arrests a person. What is to be done? To get a bail. Simple. Bailable offense, it is his right. But who will ensure that? First run is the police itself. Police officer does not release him, nor gives an option, produces him in the court. Now the magistrate, see, this is what we have done, we have seen happening. Magistrate remands him to judicial custody. Maybe wrongly, but the fellow is gone. He doesn't know his rights. And then one appears, one is bailed out. But already enough injustice has been done to him. And this is not the sole case. Maybe in states, maybe not in Delhi it is happening, but we have been hearing of cases, we have been hearing of cases like that Bhagalpur, where so many inmates, jail inmates were blinded. This was one instance. Second instance, because when you apply the existing constitution, you see, these are very learned people, professors, yes, after all, and then judges of the superior courts. They have on different occasions, they have dealt with constitutional issues. They would know what amendment is sought for, like in the case of gay-sex marriage. Honorable Supreme Court says, no, as of now, Special Marriage Act does not permit this. So this is in the hands of the legislature. Please go there. Now it is for the legislature to see. So therefore, there are ways and means of getting things done, or maybe a review may be fine, I don't know. But there are ways of getting the things done right, even in the existing scenario. See, I have already said it is all need-based. Why do we actually need a replacement? Has it worked out its life? Or is it not enough to deal with the situations? Because as ma'am rightly said, right to life and liberty, how it has evolved over a course of time. Now, it has many facets actually. You see, while working as a magistrate, I would narrate another incident. See how the things work. You need to be honest as an officer, as a police officer, because we are all otherwise part of the state. It is the duty of the state to protect people who do not have even access to justice. And this incident, which I am going to narrate now, was narrated by one senior sitting additional district judge who is now in service, and at that point of time he was a lawyer, practicing lawyer. This is of 80s, late 80s, I think I was a magistrate then. There was a kalandra filed by the police saying that this lady keeps on the sadak, she is having a dhaba, illegal dhaba, so her dhaba was removed. कलंदर आया, मैंने देखा, आई कॉल्ड द सब इंस्पेक्टर, मैंने थाने वालों का बुलाओ सब इंस्पेक्टर को, ठीक है, बिकॉज दैट लेडी टोल्ड मी एंड लॉयर टोल्ड मी सर बाकी सब, मैंने पूछा उनसे भी क्यों चलाते हो आप ढाबा बनाना सड़क के ऊपर, तो इट्स ए सीरियस थिंग। ही सेड सर सबके चल रहे हैं वहां। मैंने कहा तुम्हारा हटा दिया, सब इंस्पेक्टर को बुलवाया, तो मैंने उससे पूछा ऑल दोस, नाउ सी इट वाज नॉट दैट लेडीज राइट टू रन ए ढाबा ऑन द रोड, merely because 10 people are illegally running it, she does not get an automatic right to run it. But I still called the sub inspector. I asked him क्या हुआ, क्योंकि सर वो ढाबा चला रहे हैं। मैंने कहा बिल्कुल हटा दिया, हाँ जी सर हटा दिया। मैंने कहा बाकी तो कोई नहीं चल रहा ना वहाँ। Now he had no answer. सर वो बाकी सर, मैंने कहा बताओ नहीं चल रहे तो नहीं चल रहे, चल रहे तो चल रहे। सर बाकी मुश्किल होता है सर हटाना, सब कुछ चल रहे हैं। तो मैंने कहा भाई इससे क्या दुश्मनी, बिकॉज आई कुड सी द अंडरकरेंट, होगा क्या कुछ। तो मैंने पूछा अगर आपने सबको नहीं हटाया तो उसको भी मत हटाओ, और इसको हटा दिया उनको भी हटाओ। पर मैंने कोई ऑर्डर राइटिंग में पास नहीं किया, कलंदरे में एडमिशन करा के उसको एडमॉनिश करके भेज दिया। सो जो अब जो लॉयर थे उस समय वो भी फिर एडीजे बन के डायरेक्ट बार से आ गए, और उन्होंने ये इंसिडेंट्स, हम सुप्रीम कोर्ट में एक असाइनमेंट में थे वहाँ, सर्विंग ऑफिसर्स वी आर आल्सो कॉल्ड, और हम भी 2 रिटायर्ड ऑफिसर्स को वहाँ लगाया था किसी असाइनमेंट में। तो उन्होंने ये नरेट किया इंसिडेंट, मुझे याद नहीं था, उन्होंने नरेट किया, और उन्होंने जो सुंदरता और इससे ज्यादा बताई देखी अब आप। उन्होंने कहा सर वो जो लेडी थी उसने जो बताया, ढाबा था उसके हस्बैंड का, उस लेडी के एक्चुअली, दैट लेडीज हस्बैंड हैड फाइल्ड अ रिट पिटीशन बिफोर ऑनरेबल हाई कोर्ट सेइंग दैट मेरा ढाबा हटा दिया है ये वो, और जज साहब ने उसमें रिपोर्ट मंगाई, तारीख लग गई, वो शायद 2-4 महीने की अगले साल के रोस्टर में चली गई। तो अब इन्होंने सोचा क्या करें एज ए लॉयर, सी एज लॉयर्स यू मे नॉट, इट इज नॉट वंस ड्यूटी, ही सेड पैसे खूब बनाना ठीक है, पैसे तो जो देखो जी आपको लिटिगेंट देके जाएगा, आप लोग अपनी फीस चार्ज करोगे, ऑल्दो देयर आर नॉट वेरी मेनी स्टैंडर्ड्स प्रिस्क्राइब्ड, बट आएगा तो उसको राह तो दिखाओगे आप, भाई व्हाट इज टू बी डन, आपको कैसे काम करवा के दें। तो उसने इंस्टेड ऑफ दैट लेडी हस्बैंड, उन्होंने एप्लीकेशन इस लेडी के नाम से फाइल की, देयर वाज नथिंग इलीगल, उस पे मैंने सब कार्रवाई कर दी। तो वो उस एडीजे साहब बता रहे थे मुझे, कहने के सर वो लेडी कह रही थी जो हाई कोर्ट ने रिट में काम नहीं किया वो इस मजिस्ट्रेट ने 1 मिनट में कर दिया। See, the point is not that I exceeded my limits. No, I just reminded the police official of his own statutory duties. कि सबको हटाना हटाइए। So the point is, it is the functionaries of the state who perform their duties. If they do not perform in accordance with the constitution or other legal provisions which arise pursuant to passing of various acts, तो ये सब स्थिति होती है। लेकिन इक्वालिटी में जो हम पैरिटी की बात करते हैं, तो ये सब मैं उसी वक्त के एक्सपीरियंस से बता रहा हूँ। There were 2 police people who were caught on account of robbery, जिसमें उन्होंने कोई शायद रिवॉल्वर दिखाई थी किसी को, and when I was on leave, तो one of the accused got the bail from my link magistrate. When I came post leave, तो दूसरे की एप्लीकेशन आ गई, मैंने देखा यार इस, I told the lawyer, मैंने कहा ये तो मैंने भी रिजेक्ट की थी, मैंने कहा दूसरे का क्या हुआ, उन्होंने कहा सर उनको तो फलाने ने बेल ग्रांट कर दी है। ये सुनने के बाद then it occurred to me कि भाई अब अगर वो भी बेल पर रिलीज हो गया है तो एटलीस्ट इक्वल ट्रीटमेंट तो होना चाहिए। If the facts and the alleged acts attributed to both of them were identical, why should there be a differential treatment? Writing down all this, I granted it. So और सर अखबार में छापना विद रेस्पेक्ट आई वुड से हमने भी काम किया। क्या होता है, जर्नलिस्ट सब कोर्स में घूमते हैं सब जगह, तो खैर बड़ा सिस्टम इज इन प्लेस। हमारे वक्त में उतना अच्छा सिस्टम नहीं था, पर जर्नलिस्ट 20,000 में भी आते थे, सबको पता पटियाला और उसमें भी सब जगह आते थे। स्पीकिंग फॉर माई सेल्फ, हम देखो जी वो उसको फियर शब्द आप जो मर्जी इस्तेमाल करिए, फियर, इंटेग्रिटी, ऑनेस्टी, इंडिपेंडेंस, व्हाटएवर, पर उनको हमेशा बताया कि हमने इसमें पार्टी नहीं बनना छपवाने में। उस समय भी लोग कॉपी लेते थे, सब कॉपी लिया आपने जो मर्जी छापो, कोई बात नहीं, पर मुझे नहीं लगता कोई जब मेरे लेवल का डिस्ट्रिक्ट जुडिशरी का ऑफिसर नहीं करवाता था तो ऊपर वाले तो शायद कभी ऐसा तो खुद कह के करवाएं कि भाई जरा इसको, और ये ठीक है, सोच सकते हैं। सोच तो तभी आएगी when there is a need. It's all need based. If there is no need, there is no point in doing such a huge exercise. I was reading वो जो कॉन्स्टिट्यूशन है ओरिजिनल हिंदी और इंग्लिश में हैंड रिटन है। It is still preserved in the parliament. So very much for these words. As of now, there is no need. Objective can be achieved through amendments and other facilities available under the Constitution. Thank you so much.
Thank you so much for your words. Please, sir, you have learned a lot from experiences.
Makes it easy for me because I can say I endorse what all of them said. Being the last to speak makes it difficult for me because I have nothing left to say, nothing new to say. But still, I'm conscious Aditya has been worried looking at his watch time and again we have overshot the time allotted for this particular exercise. Nonetheless, I'll first respond to what Mr. Badrinath said respecting the legal fraternity. He somehow equated it to vultures and something like that. It reminds me of a cartoon I saw where a ship lands on the South Pole and there is a flock of penguins. Now, contrast it. A child visits a boardroom. A child who has seen those penguins, group of penguins. He says, why are all these people dressed like penguins? We in the legal fraternity do dress like penguins. We are not vultures. But we create a cacophony like penguins. But then it's all for a purpose. We also stand and serve in our own way. Coming to the subject at hand, do we need a change in the Constitution? Change is law of nature. Something which doesn't change becomes stagnant. It stagnates, becomes stale. You avoid, you shun what is stale. As Professor Jaswal said, it's the good norm, the suprema lex, that's what our teachers taught us. Those words are pregnant with so much of meaning and possibility. It's the prerequisite of any modern state. Today, world is more connected than ever before. We could all live in our own sweet islands with our boundaries intact in medieval times, only defending when somebody attacks us, or those with expansionist ideas would cross over the boundaries. But today, the interaction, the human intercourse, whether it's social, political or economic, that has a ripple effect over all over. We all know India is now the 5th largest economy in the world. We take pride in the fact that we are the largest democracy, the 2nd oldest democracy, oldest representative democracy. UK, Britain had its constitution well written, but then it has been a monarchy, unlike us. We chose to be a republic after our independence. This document is our not only dharma or our soul, as Professor Jaswal said. It's probably, you can call it Bible, you can call it Gita, you can call it Guru Granth Sahib. It guides those who are entrusted the job of governance. Governance in the sense steering this ship that India is on its journey to the brighter future, towards that rainbow which it promises to us. This document is the fruit of labor of love of our founding fathers. Founding fathers who were not actually chosen in this sense, the way we hold elections now. Founding fathers who had participated in the freedom struggle. Founding fathers who represented all walks of life, whether it's law or science or agriculture sector, you name it and you had them. From all communities, Hindu, Sikh, Christian, Islam, all followers were represented. So it's the unified vision of that constituent assembly, those visionaries which will remain, have remained unparalleled until today. And maybe the way we are going, that egalitarian approach you may not achieve in near future unless we repair the fractures that we have created within our polity, unless we win over those who have secessionist ideas, unless we win over those, unless we satisfy those who believe in only criticism for the sake of criticism. As was rightly put repeatedly, lastly by my brother Mr. Saxena, the question would be, why do we need to change? Why do we put this poser at all? Or when do we put this poser? Your wardrobe is old, you want to change it because you are bored with your shirt or your dress or your apparel, or it has outlived its utility, or it has worn off. You want to change your footwear it has started pinching. Its soul is gone. Soul not in that sense, soul in the other sense. That's the difficulty with English. It has similar sounding words, but with different spellings, and they create confusion. Anyway, you change, you seek to change, say your calling, your business, the profession you have chosen, because you are dissatisfied. It's not giving you that kind of satisfaction as you hoped it would. You seek to change, to have some experience on the other side, like Professor Badrinath. He was a journalist who is supposed to be a critique of the government, of the establishment. Now he is part of the establishment. He is looking it from inside. You seek to change because there are better alternatives. Those are the posers you have to put to answer the question which we have for this session. This question was put some 20-25 years ago. After we completed 50 years, we had a committee set up by the lead in central government to examine this aspect. This question was put probably during that dark period of emergency, when 42nd Amendment was brought in with radical changes, some of which are still retained in this constitution. For example, the chapter on fundamental duties, but some of which have to be again written off, struck off by the subsequent parliament, because those changes were with an agenda. That 42nd Amendment, I am sure you all are aware, is also known as mini constitution. For this exercise, to answer this question, you have to actually put the pros and cons, pluses or minuses in a balance. Once you put these pluses and minuses on the balance, you will see the answer is very clear. Now let's quickly flag what are those pluses in our constitution. It creates for us a democratic polity. We have a historic connect. Our history, which dates back much more than any other current civilization across the globe, is this notion of democratic system of government. We chose this system, so we can't grudge it. But then that's part of the electoral reforms, not a problem with our constitution. The main feature of this constitution, and I'm not narrating those basic structure theory. Main feature of our constitution is rule of law. Every authority, every body, every institution created under this constitution is under a rule of law. Even the president is bound by the rule of law. Even the president's power are defined. If there is if the president exceeds that power, for example, in commutation of sentence awarded by a court of law upheld right up to the Supreme Court. Even that commutation can be challenged, has been challenged. There is a theory which says the legislature represents the sovereign power, because we the people create that legislature. Speaker has a pivotal role in the legislature. even speaker is bound by the rule of law. He cannot allow a bill to be brought for legislation in a house which is not within the domain of that legislature. For example, I am referring to this distribution of business by those 3 lists. Distribution of business. Even speaker is bound by rule of law. You would have read this defection issue in Maharashtra Assembly, which is doing some rounds in the Supreme Court. This system, the present constitution, comes with a fine mechanism of checks and balances. Each organ is controlling the other. There are 3 organs. They are counts of the state power. Each organ is controlling the other. This constitution gives to us an inclusive democracy. Inclusive in the sense we all are equal. We all have right to equality. We all have a right to equal opportunities. And that's now showing after 76 years. A reservation policy which was meant as affirmative action to bring up those who had suffered over the recent history for various reasons. They also had to be pulled up, given some advantage in finding, in pursuit of their aspirations. The affirmative action, which was meant initially for 10 years, has continued till today. And if you see those 106 amendments last in January of this year, where this women reservation bill came, majority of the amendments relate to reservation issue. Apart from reorganization of the states, resetting of the boundaries, majority of the amendments relate to affirmative action. Fundamental rights, I think enough has been said. We are a welfare state. Directive principles of state policy, which is something we adopted from the Irish Constitution, borrowed from the Irish Constitution, but then we fine-tuned it for our purposes. Article 39A, then Article 51. That's the beauty of this Constitution, which says we work for international peace and tranquility. We have a global vision. We declared a global vision right on the first step we took. The aim of peaceful coexistence. Now come to the minuses. We can add to the pluses. Many more are there. On minuses side, there has been failure on the part of the judiciary, which is the guardian angel. When did this occur? ADM Jabalpur case. You all would have read it. When did it occur? During that dark period of emergency, when judiciary was tamed. Then comes 1977. I think we left that period behind. Thereafter, we have made giant strides. Judiciary, as Professor Badrinath was lamenting in a way, that judges are saying some things in the court to create news. Sorry, sir. Judges, the 50% of your media coverage concerns what is happening in the court, because judges are active. Judges are proactive. Judges have been filling in vacuum where it is found. Example, harassment of women at sexual harassment of women at workplaces. Vishaka case. There was a vacuum, judges filled in that vacuum. This constitution, on minus side, yes, this constitution is lengthy, but then so what? Unlike unwritten constitution of UK, unlike yet brief constitution of USA, it gives us details. It gives us not merely a skeleton, it also adds meat to it wherever it requires. Because the lengthier the narration in the law, the more debates on semantics, more debates on comma and full stop and colon, but then so be it. It generates debate, and maybe over the period we fine-tune it. Amongst the minuses, I also say there is a good school of thought questioning the reservation policy. How long will it continue? Should it continue in the same shape as it was introduced in the beginning? Is meritocracy not suffering on this account? Are we not expanding it more than it was required? By now even suggesting let's cross that 50% ceiling. But then my question to all of you and to myself would be, are these minuses because there is something lacking in the constitution? No. The answer has already been said. The constitution has not failed us. Constitution is a wonderful document. It would have failed at some times. It might fail again because of those who work it, because of those who are responsible for governing us through this constitution. We have reasons to be happy. We have made economic progress. There is a way forward. Question again would be, is there a better alternative? Europe, I am sure all of you are vigilant, aware, young persons of this India, future of tomorrow. The future leaders of tomorrow, rather. You would have been keeping abreast with what is going on elsewhere in the globe. Ukraine war has been there for more than 1 year. Gaza-Hamas war is there now, entering second month, has already crossed into second month. India is a peaceful, peace-loving state. We are all peace-loving state. We have shown to the world that we can also live peacefully with each other, despite our diversity. There have been issues in the past, there have been communal flare-ups, but then they can be handled, they were handled, they would be handled hereafter also. We have the best of laws, but the problem lies with the agenda of certain section. The problem lies in enforcement. US Constitution was adopted in 1789. They have not even bothered to think on this question at all these years. More than 200 years. Europe has been toying with making changes. France was referred as some 16 constitutions. I read only last week or so, Argentina had elections. They are thinking of junking their constitution, bringing. Netherlands again has chosen its new leaders. Again they are thinking of making changes. Italy did so only recently. They are all moving towards ultra-nationalism. You understand what is ultra-nationalism? Same principles, same theories as Nazi party of Hitler had started with after the First World War. That's a dangerous path. Do we want to move in that direction by bringing up this question? Do we have a better alternative? Monarchy is something which occurred in medieval times. Even Britain is rethinking now whether to have a new king after King Charles at all. We don't want to go into a theological state like Pakistan. We know where Pakistan stands today. We don't want military rule, we don't want oligarchy. This is the best form of government. Change and continuity can go hand in hand. Please don't think or even suggest remotely to shun a good ship. Let's continue on this ship. Talking of change, I'll just give you one example. The government has constituted a committee only recently which has presented a draft of new Nyaya Sanhita and whatnot, criminal law amendments, IPC, Evidence Act and Code of Criminal Procedure. I am appalled at seeing the changes being suggested. I am appalled at the way the committee has steamrolled all opposition, all suggestions and has now moved it to the, placed it before the House for adoption. We don't want knee-jerk changes at all. It will demolish the existing criminal justice system in this country and do more harm than it is going to take good. So, to conclude, I'll say Navya, where is Navya? She started on a right note. She said at the beginning, and she had already given the answer. She had already given the answer in her opening remarks. This is a good law. We don't want change. This supreme law only needs amendments. And amendments, I'll say, let's restrict themselves to the federal structure. I'll say, let's restrict it to the role of the Supreme Court. As a judge of a constitutional court, which I was till 2019, I can say Supreme Court is exceeding its powers. We are sitting in an academic discussion. We are sitting in a house where we can have our free views. I'm sorry, I chose the wrong words. Not exceeding its powers, it's exceeding its role. It was meant to be a superior most constitutional court. It was meant to deal only with constitutional issues. It's not meant to deal with bail for this matter, bail for that matter. No. Supreme Court should leave those issues to the high courts, which are the Supreme Courts for each state, which are the final constitutional courts for each state. The power of amendment of the Constitution is what makes it what was called as living document, living organism. That power has been used 106 times. All those changes did not stand the scrutiny. For example, NGAC Act, which was struck down. The amendments for that were struck down. I have a different view than what Supreme Court ruled on that subject. Nonetheless, that power is excised. I'm sure your constitutional teachers would have taught you that power is excised by the parliament in its constituent power. When the parliament sits to bring about an amendment of the constitution, it is not sitting as a union legislature in ordinary sense. It's sitting as a constituent assembly. So we already have a constituent assembly which is continual, which is continuous. If any changes are required, they can always be brought in exercise of that power. So I believe there is a consensus amongst all 5 of us that the answer has to be effective. We don't need to change the constitution as such, but we need changes in the constitution, existing constitution. That's how I'll request this House to adopt the resolution.
Really enlightening, really knowledgeable. But sir, taking the view of all the panelists we have over here, there was a general view that the soul of the constitution is the basic key on which a constitution realizes. It relies upon. The preamble, we can say that time and again Supreme Court has also said that it is the soul of the constitution, which has to and which has been intact since the constitution was formed. But sir, and it is a fact that when the constitution was drafted, the 2 words which you talk about a lot in the soul, socialist and secular, were not present. And not as a chance of mere avoidance, I like to say that Loknath Mishra, the elder brother of former Justice Jagannath Mishra of the famous Jagannath Mishra Commission, he said that the word secular was purposely kept out of the constitution, not because of mere avoidance, but with purpose, discussion and debate, so as to not create any further confusion in the constitution because of the Article 25 we see. Because Article 25 says that the control specifically of the majority community Hindus, their religious places and temple can rest with the government so as to abolish a few practices here and there, which we saw in the case of Sabrimala judgment. Can't we say, sir, that the soul of the constitution has already been violated? Because even with the addition of the word socialist, Dr. B.R. Ambedkar was against the word socialist because he said that today we might like the ideology of being a socialist country, but from years coming, the people of my nation, my country, my countrymen might not like this ideology. I don't want to bound my countrymen. These were the views and the words of Dr. B.R. Ambedkar, which were later changed on by Pandit Nehru because of the socialistic ideology. Please, it's open to all the panelists. Please, ma'am, please.
Very right. Socialism and secularism, these words added by 42nd Amendment in 1976. But it's really wrong to say that we were neither socialist nor we were secular before that. For that purpose, in fact, you have to read clearly Articles 25 to 28. And at the same time, I would like to remind that even when we talk about our fundamental rights, mainly the island of right to equality, when we say no discrimination on certain grounds, one of the grounds is religion. And when we say no discrimination on the ground of religion, then what we mean by it? It was merely addition of the word secular. In fact, I always say that we have to change our mindset. No religion teaches us that we don't have to be tolerant. How mindset is to be changed, I can give example of the decision by the Supreme Court in Aruna Roy versus the Union of India in 2002. So what happened there? Our mindset. Education policy, decision of adding value education classes in the school and in the value education classes to teach the basic tenets of different religions. You know, this was challenged. Our mindset. I am Hindu, why should I be told about Muslim religion or Christian religion? But this was not rejected by us. The reason being that we are secular, and the tender minds, the tender hearts who study in the school at that age, if they understand the basic tenets, the basic teachings of different religion, they will develop tolerance. And then we will not read in the newspapers communal riots. And I can also quote Vijay Emanuel's case. All of us know about the students of constitutional law. How two students from Jehovah community, they refused to sing the national anthem in the morning assembly. And the Supreme Court decided in their favor that if they are standing in respect, even they are not singing, isn't violated. Supreme Court, in fact, Justice Ochithamari beautifully said, our tradition teaches tolerance. Our culture preaches tolerance, and our constitution practices tolerance. So that means this concept of secularism was inbuilt. It is not an attack on the soul of the constitution. Again, coming to the preamble only. When we talk about fraternity, what is fraternity? Fraternity is brotherhood. And fraternity is not possible without this harmony. I can simply I wrote some poem on this also. Exactly, I don't remember the words, but it was like, जब कीर्तन, आजान, प्रार्थना सबके होते हैं एक सुर सप्तक। जब कीर्तन, अजान, प्रार्थना के होते हैं एक सुर सप्तक, एक ही ड्योढ़ी में दरवाजे खुलते हैं सभी के, तब सामंजस्य सोता है। We were a socialist. No doubt, we may not talk from the ideology of Karl Marx. We talk from the ideology of Mahatma Gandhi. When he talked about Indian socialism, where we talk about mixed economy. Even though we are diverting, we had common share for public and private sector. Now we are diverting as per need. For that also we have certain reasons. Again, coming back to the Vedic scriptures, when we say Vasudhaiva Kutumbakam, the whole earth is our family. It's not practically possible, but at least we can make efforts. Now, what is the socialism? I can quote a number of decisions, especially I can talk about 1997 Samatha versus state. Here Supreme Court said, when the state protects every individual from cradle to the grave, when our standards of living are raised, that is socialism. And mind it, we may fight for negative equality. Don't violate my right to equality, and the court may grant us relief. Relief maybe after years, by the time generations vanish. But if we want positive equality, real equality, equality among the masses, we have to look into the directive principle of state policy. Look at Article 39, all the clauses. You will find socialism. Thank you.
Thank you. So actually, the real question, ma'am, as you said, that we are secular undoubtedly. But what happens to our secularity when we talk about Article 25 and selectively we say that the government can interfere into religious
No, sir, can I?
Please.
This is not so. Supreme Court of India in a number of decisions again has distinguished between religious and secular activity pertaining to any religious institution, any temple, any mosque, any gurudwara. Secular activity. Now we have examples like the old case 2002 Church of God's case, where The Christians, they have right to say prayer but not to use loudspeakers. Because we have right to live in a healthy environment. Similarly, in 2020 there was a decision by the Nishtha High Court. It is not everywhere on the roadside you just build a temple and leave. So this, if the state interferes, state can interfere in the secular activity, not in the religious activity.
That's what I was trying to question, but with the paucity of time I had to reduce my question. In the Sabrimala judgment, we saw that secular logics, although I personally disagree from the Sabrimala judgment and very respectful of the Supreme Court judgment, I know, we saw that secular logics were being applied to a religious place when specifically that was a deity who himself said, as per the scriptures, I am not to speak about him, as per the scriptures he himself said that I am living away from the city, I am living away from the civilization, so as to attain a particular dhyan, and women, I am keeping away from women not as they are subject of discrimination because I want to attain my solidarity. And a lot of women were standing in favor of that because they believe that that belief is true, and many women were also standing that we have to gain entry into the Sabrimala temple.
They don't confine merely to Sabrimala, this is under review. And even I am a great critique of Sabrimala, I just don't agree with the decision.
Right.
In the sense, I am in favor that yes, by virtue of Article 13, no such discrimination. Gone are the days when such issues could have been raised. We are in which century? Now here women can do anything, they don't have any issue. And the problem is again that nobody wants to hurt the religious sentiments of some segment of the society. I don't agree with that. What kind of practices are religiously going on, but that may be my personal view. So let us decide on logic, but that doesn't mean that we are losing secularism.
I would like to add a little bit of this.
Please, sir.
In fact, equality of sexes is very important.
Right.
Anything which defeats equality of sexes has to be seen from that perspective. Because Hindus, there were many beliefs. Like a widow was just burned alive. That had to be changed. When the change was sought to be brought, it was opposed. People alleged at that time that we were interfering to our scriptures, our hollow things. But the thing is, that had to be changed. Similarly, this kind of connotation, that women are not equal in certain circumstances, this too has to be changed. In favor of that judgment which had come regarding Sabrimala and this because I'm a very staunch believer of equality of sexes. And those who think that the sexes are not equal under certain circumstances and therefore justified because it is written in scriptures and all that, I say that we have to remain a living society, a living religion. Old things like you don't have to burn a light, that has to be done away with.
Right.
You can't live with those kind of things. There are many more things about Hindus which require our attention to be cured. Like I referred to caste system.
Right.
We need to create a society where everybody is equal. And it is not that easy. That is why there are a constitution, although reservation over 10 years, it is increasing by every 10 years now. So we have to have a situation where we address these kind of issues about Hindus and about others also. It's not only that we should get the Hindus also used to marry more than one woman. But that had to be changed and it was changed and right to be changed.
I'll only add to what has been said from a different perspective. Contrast Sabrimala with Vaishno Devi. Vaishno Devi Shrine Board is also a way of interference by the government into religious affairs. But it's is it really an interference? No. It's more of a regulatory function that the government performs. The CEO of Mata Vaishno Devi Shrine Board is a government functionary, but then entire management of the affairs is by the custodians. Something similar is happening vis-a-vis Kalka Mandir and Kalkari Mandir in Delhi. It was all in the making because their claims were clogging the courts with right of recovery of the chadava that was coming. Ultimately, it all turned out to be a money-making machine, which is ugly, which is nothing to do with religion, practice of religion. The government had a role there, but then the way it did was to take over that institution. Unlike this, Sabrimala remains a private institution. There was a jurisdictional issue raised which was not properly addressed by the Supreme Court. J. Sai Deepak he has spoken very extensively on this. The money which was flowing from the government to the management of Sabrimala, that was the ground on which the state government said we have a right to interfere because we are giving grant. J. Sai Deepak brings out that's not a grant. That's a money owed by the government under some royalty agreement way back. So under that misconstruing of that flow of money, the Supreme Court probably assumed it's an institution which receives money from the public exchequer, so it's a state-controlled institution, so we have a right to interfere, right to speak. Probably that's where the court has faltered, and I hope it comes to some review someday.
Right.
And court is not a place to test my belief, test the correctness of my belief. Even I can't test my belief. Belief is something you don't question.
Thought, discussion. What is the local standard of the court to decide who prays and who doesn't pray? Is a basic question. Do they even have the wherewithals to decide the tradition of a Hindu dharma or Christian tradition or Muslim prayer or something? So it's a louder question, that's all. I am not talking about which law, which constitution, which because I am not a lawyer. Point is, should we not leave it to the dharmic people to decide? Let there be a debate and discussion. And let them decide, rather than we becoming experts of everything. Why do we have to do that? Why do we have to take upon ourselves? Yeah? Is it not for the Hindu society to decide what they want to do? If they have to reform, let them reform. If a woman of a particular age or a group or something doesn't, she is going through a particular cycle and she is not going to go somewhere, how do you want to force her? Can you force every Muslim woman to wear a hijab? By the directive of the court of Karnataka? Or can anyone say that, okay, what is the kind of prayer a Protestant church has to hold? How do we decide these issues is a larger question. Management of temples or traditions cannot be left to a judge or IAS officer, no? Should it be that way? Think about it. Because I am not particularly an expert on it. The point is, many a time it becomes a subjective director. What I believe is it becomes a director. What the society in Kerala wants, have we ever taken it on board? There were 1 million people on the road saying that, okay, this tradition has to be protected. It included all ages of women. If that is the case, has the court not erred on the judgment? How do you say that, okay, no, this is discriminatory, henceforth this should be abandoned? Reason, logic, and some kind of an argument to say the richness for saying it. Otherwise 1 million people will not come on to the streets of Kerala, no? Saying that this Sabarimala tradition has to be protected or should be continued, or maybe in a reformed way. Leave it to the Hindus to decide. For example, you want to take over all the assets of Padmanabha Swami temple because it's billions of worth gold there. Now when the tradition says the 4th floor should not be open, you try and open it. If there is corruption, yes sir, the Lordship should decide if there is corruption there or not. If it is mismanaged or not. Getting into issues of tradition, dharma, or how the Bible should be interpreted, or the Quran should be interpreted, or the Kirtan should be interpreted, is something perhaps we need to look at how we should do it as a society and stakeholder, rather than sitting on judgment on which I am not expert to talk.
Thank you, sir. With the paucity of time, let's have a question from our audience. Anyone in the audience who may have a question from our panelists, please more than welcome to you. Mic will be presented to you. Please stand up at your place respectively. Please direct your questions to the panelists who want to ask them.
Good morning to all the panel members. This is Gunika Malik from PNLB First Sem. My question is to Professor Dr. Nishtha Jaswal. How has the social economic landscape of India changed, and do these changes necessitate constitutional revisions to ensure more inclusive economic policies and social welfare measures?
Ms. Malik, very good question. In fact, since the inception of the Constitution, we are struggling with all socio-economic issues. Right? We are well aware of the land reforms. We are well aware of addition of 9th schedule. That because of bringing land reforms, what we did, that even when any act is placed in the 9th schedule is not subject to judicial review. But nothing can be so unlimited and unrestricted. So ultimately, Supreme Court only talked about it. That yes, you cannot put it to judicial review, but if it is a violative of a basic structure, Iyer Coelho's decision of 2007, then, and with the passage of time, so many laws have been passed. See, we talk about socio-economic justice under the directive principles of state policy also. Till date, we are struggling. All of us are well aware of GST. A GST to be collected by the center to further distribute. Now, problem doesn't lie in what we lay down, how we legislate, how we amend. Problem mainly lies in implementation. Now, that problem is going on regarding this disbursement further. Similarly, if you talk about social justice, as we have already discussed, that already this finds place in the preamble. And what is the social justice? Social 39, Article 39 also if we refer to equitable distribution of material sources. Right? No discrimination. But ultimately, I can just make one statement that we have a wonderful constitution, so many social reforms, all the laws pertaining to vulnerable sections of the society, like we were just talking about the law prohibiting sati, right? But still, you know, we have a constitution which has no staircase or escalator. 3 levels we have. Top level, those who enjoyed all comforts, all the riches, they made rich. They did not come down, we did not have a staircase. They could survive there, they could settle there. We have the lowest level, poor people, the majority of population languishing in poverty. Even if the Supreme Court elaborates number of fundamental rights, even if we have public interest litigation or affirmative action, you go and ask this population, they say, we are only concerned with 2 square meals a day. We don't know what are human rights. We don't know what are fundamental rights. And who will waste of the time? Who will waste when we are daily earners? And as Shri Badrinath ji said, who will go to these Kalakot walas for this purpose? Right? Middle level, now because of no escalator, always sandwiched. I think we have
I give up. I give up.
Thank you.
Thank you.
Now with such learned panelists and such an amazing discussion, even the entirety of the time would feel insufficient, but there we have it. That was about for today's panel discussion. Well, on the occasion of Constitution Day, if the Constitution were to be present himself here, he would have just one thing to say. What I am capable of, in the words of Game of Thrones, you know nothing, Jon Snow. Thank you very much. That is your panel discussion.
Students at the back, please keep sitting. Hello.
Guys, please make your attention. The panel discussion is over, but there's still a little bit left. So please have your ears pinned to the mic and the speaker.
Well, thank you all the panelists for enlightening us and sharing your excellent knowledge here. Further, it's time to celebrate the talent of our hard-working Legal Aid Credit members. I would like to request our respected Vice Chairman Sir and all the esteemed panelists to felicitate the members one by one. So firstly, I would like to welcome Mr. Retd Singh Rajawat on stage.
Next, I would like to welcome Saxena, Vice President, Legal Aid Clinic, for her dedication shown during her tenure.
Further, I would like to invite the Legal Aid Clinic coordinators one by one. Please welcome Divyanshu Jain. Narola. Can we please have Prerna on the stage? Next, I would like to request Shrishti Bansal. Please welcome Kirti Anand. Please give them a huge round of applause, guys. Thank you. Well, now, it gives me an immense pleasure to announce the next President and Vice President of Legal Aid Clinic for the new term. For the post of President, please put your hands together for Siddharth Singh Narola. Shrishti Bansal. Let's please give them a huge round of applause. They deserve it. Director sir to felicitate our distinguished guests with the memento. Next we have Honorable Justice P.K. Saxena sir. Further, we have Mr. K.A. Badrinath, sir. And last but not the least, we have Advocate Bharat Bhushan, sir. Thank you so much, sir. Now, I would like to request our esteemed faculty coordinator, Dr. B.K. Yadav, sir, to come on this podium and deliver a vote of thanks. Thank you.
Very good afternoon to all of you. It's my great honor and privilege for me to propose a vote of thanks on the occasion of Constitution Day today. I am grateful to our respected guests of their valuable contribution and encouragement. First of all, I am thankful to Honorable Justice R.K. Gauba, former Judge High Court of Delhi. Sir, we all welcome you and we need your blessing in further on. I am also thankful to Honorable Justice Saxena ji, former Additional District and Session Judge. Sir, we all welcome you and we need your blessing and guidance in future also. I express my sincere gratitude to Professor Dr. Nishtha Jaswal, Vice-Chancellor, National Law University, Simla. Ma'am, we all welcome you and we require your blessing and guidance in future also. I would like to thank Mr. K.A. Badrinath ji, Director and Chief Executive and Principal Advisor, Ministry of Information and Broadcasting, Government of India. Sir, we need our continuous guidance and support in future in order to change the constitution, because today we have light one candle in Gita Ratan, and Nishtha ma'am is there to support us to go further in this way. Thank you to you, sir. I would like to thank Advocate Bharat Bhushan ji, founder of Bharat Associate. Sir, we all welcome you and need your blessing and continuous support, sir. And I am very thankful to our VC sir and Director sir who has given the continuous support to make this program successful. I also extend thanks to all the staff members and beloved residents and their continuous help and cooperation. Thank you to all of you. Good day and Jai Hind. Thank you.
Punjab, Sindh, Gujarat, Maratha, Dravida, Uttara, Banga, Vindhya, Himachal, Yamuna, Ganga, Ujjala, Jaladhi, Taranga, Tava Shubha Name Jage, Tava Shubha Ashish Mange, Gahe Tava Jaya Gatha, Jana Gana Mangala Dayak Jaya